guess we're ready to go back on the record. Everybody accounted for? We'll start this afternoon with Mr. Jay Krupin, who will be followed by David Madland. Good afternoon.
Good afternoon.
Welcome.
Thank you very much, Madam Chairwoman and distinguished members of the board, for this opportunity to speak on the significant changes that you have proposed and the certain impact it would have on the American workforce and the American businesses throughout the nation. My name is Jay Krupin, and I have practiced traditional labor law for more than 30 years, and I am the chair of Epstein, Becker, and Green's National Labor Practice. I also serve as outside labor counsel to the National Grocers Association, which is the national trade group representing more than 1,500 independent retail and wholesale grocers. Most of its membership is comprised of family-owned and employee-owned businesses operating in communities across America. Nearly half of the NGA's members are single-store operators, and another quarter operate less than 5 stores, in addition to the large regional multi-store operations and wholesalers. Grocery stores and wholesalers operate on very tight margins. Many independent grocers' budgets do not allow for human resource specialists, compliance departments, or labor relations professionals. In short, the small business owner and even the large retail operators have no or very limited expertise in the maze of rules and procedures governing the NLRB elections. Although there are numerous objectionable aspects to the board's proposals, I will focus here on the dramatic reduction in time that an employer would have to respond to the union's campaign, most of which has been ongoing for months without the employer's knowledge by the time that the union petition is filed. In representing employers in over many campaigns, it is clear that unions do not generally broadcast that an organizing drive is ongoing. Under your proposal, the current median time frame under which an election is generally held, within 42 days, is cut to less than half that time and could be held in as little as 10 to 21 days. Under such a system, employees will be rushed into making a decision without the benefit of an opportunity to receive and digest information, contemplate the consequences of their ballot, and review and question information. It cannot be maintained that less information before voting is a laudable goal. Rather, your proposal transparently precludes sufficient time for employees to receive and consider information which dramatically affects their workplace and their lives. It makes the election process for employers to be an away game. Under Section 7 of the Act, employees have the right to form, join, or assist labor organizations, as well as the right to refrain from any and all of such activities. Under Section 8C of the Act, it specifically protects an employer's expression and dissemination of views, arguments, and opinions. Your proposal's strident time limits on the campaign period before an election undercuts the goal underlying these twin pillars that uphold and give full meaning to the secret ballot, namely the free and full exchange of information. Both provisions assume an employee's right to receive information, to hear and express views of others, informing their conclusions regarding whether to join a union. By restricting the employer's statutory right to express and disseminate its opinion, the proposal to the same degree restricts employees' rights to receive and evaluate that same information and to weigh it against competing claims prior to casting a ballot. In striking down a statute which restricted union organizers' rights to disseminate his views to employees, the Supreme Court long ago decided that the statutory right protecting an employee's choice of a representative further protects an employee's full and free right to discuss and be informed concerning his choice and to hear the views of others. A secret ballot does not a fair election make, and the right of free speech is meaningless if there is no time granted to speak. An election is a process. It is a means, not an end. A fair election is not simply the marking of a ballot. The right to vote by secret ballot necessarily assumes the opportunity for the elector to have freely and fully exchanged information and ideas, and to debate and test the veracity of claims made, which itself assumes sufficient time to engage in debate, to receive information, and to review all aspects of the contemplated decision. In short, the secret ballot is a culmination of a process, not the process itself. The board's proposed rules ignores this reality. It eats out the substance of a secret ballot. There is an inseparable bond between a fair election and the right to be informed. The link between employees and any representative they elect can only be validated if it's forged by free and full participation of the employees. Frankly, the proposal's shotgun time limits tramples on all the elements that make the election legitimate. Discussing the board's proposal, the NLRB website notes that the proposed amendments are designed to fix flaws in the board's current procedures that build in unnecessary delays, and that an important result has been to reduce the typical time between the filing of the election petition and the actual election. Only in the mind of a union partisan can the few short weeks between a petition and the election be referred to as an unnecessary delay. The proposed rule leaves no doubt which side it supports, and it is not on the side of a neutral, balanced, and fair approach which protects and holds sacred the employee's right to choose. Viewed through the lens of the board's legitimate role as the protector of an employer's First Amendment and statutory right to express and disseminate its opinions and views, and the employee's right to receive such information and cast a fully informed secret ballot, the board's proposal is exposed for what it is, a process of pure form with the intent to stifle the contemplation of substance and of free speech. The NGA is hopeful that you will have heard these expressed views, that you will fully consider these remarks and comments, and through your deliberations, you can strike an appropriate balance to protect those who are most affected and harmed by your proposal, both the employees of America and America's business owners. Thank you very much.
Thank you, Mr. Krupin, for your comments. Anybody have questions?
The current system, in terms of the value which you so eloquently articulate and which we take very seriously and which is embedded in the Act, the ability to communicate freely, seems to hinge the time period over which that right can be exercised on something which, at least in my view, is completely irrelevant, which is the degree of litigation. That is, you may have a very short period or you may have a very long period under the current system, depending on how much the parties litigate, which seems to me to be completely irrelevant to the values which you articulate. And if you look at the board's previous statements concerning what that time period would be, you find, for example, Modern Interiors, 324 NLRB 164, a case decided in 1997, and it's then codified in the case handling manual, and it says that the union must have the Excelsior list for a minimum of 10 days. So that seems to be a statement of a prior board that in terms of the union's ability to communicate with the entire workforce, which it doesn't have until it gets the Excelsior list, that 10 days is a sufficient period. But I guess my question is, how do you make that judgment? You certainly have to agree that it can't hinge on the amount of litigation. That doesn't make any sense. So how should we make that judgment? Should we look at that case? What should be our criteria?
I'd rather we be very practical. The union has had an opportunity to speak to employees. We shouldn't be under the misconception that the first time the process begins is when a petition is filed. As you well know, they've had to gotten a showing of interest. At least 30% of the employees in the unit, or the appropriate unit that they determine, should have decided that they wish to be represented by a union for purposes of engaging in bargaining for terms and conditions of employment. Most unions will tell you that they won't even file the petition until they've received cards signed by 70% of the employees for the possibility of attrition. So let's not start by assuming that the day that the activity occurs with the union is when the petition is filed. Now, I've heard before, and I'll tell you, I've had many elections, many campaigns. most employers do not know what's happening. Unions don't broadcast the possibility, telling employers that there's a petition going around, or cards going around, or there's a campaign for organizing. So when the employer now hears about it, they basically are in the third quarter of the game. The union has already gained momentum. And therefore, the issue of the Excelsior list is not as important, frankly, as I think this board is making it. The union knows the employees. They know the people in the unit. They know who signed cards. They're not just becoming unique to this process. And so what really happens is, if it's going to be a fair process, when the employer now knows about it, and this is irrelevant of whether employers win or lose the election, or whether unions win or lose the election. It's a matter of having a fairness to the process of being able to know the information. The union's been on the field for a while. Now the employer hears about it. Now the employer gets on the field. And frankly, 42 days, which is the present process, sometimes is not enough and sometimes is too much. But the very fact is, it's a reasonable time period for the parties to trade information. And it's not just the employer information. As you well know, there's misstatements of fact. There's issues that have to be reviewed. Look at our system now in our civil elections. We don't just have elections in 10 days. We have back and forth. We have to digest the information. That's why your proposal to reduce it to a 10-day period possibly is abhorrent to what we think is a democratic process.
Well, I think your assumption that the reduction will be
I'm sorry, I couldn't hear
the reduction will be 10 days is speculative, because each case is going to produce different things. Certainly, if a case goes to hearing, an election is not going to be held in 10 days. Now, with regard to the part of the proposal that deals with the elimination of that 25-day period after the decision and direction of election before an election can be held, when statistics and experience shows that period of time is wasted time. The board does not grant stays of elections before it grants reviews in any more than 1% of the cases. The elimination of that, are you saying that the elimination of that is denying the employer a particular right?
Yes.
When that process itself did not contemplate party campaigns at all when it was put into place?
I'll tell you why I believe it is a infringement on the right. Because once a decision and direction of election is issued, whether by a regional director or through a stipulation to have an election in your 25-day period, that's when the terms of the election are set. That's when you know the rules of the game. That's when you know the field's 100 yards long and you have 11 players on each side. Before that time, we don't know. The union doesn't know. The employer doesn't know. What are the rules of the game? The appropriateness of the unit, who can make certain statements during campaigns. Remember, employers do not want to commit unfair labor practices. I've heard all this discussion about coercion, intimidation. Employers don't want to commit unfair labor practices. In fact, there are dire consequences if you do. So we're talking about less than a month period, once the rules are set, to be able to go forward and to now determine whether or not this union should or should not represent the employees. Note, my issue here is not a determining factor of being partisan to try to say employers should be always positioned to win elections or unions should be positioned to lose elections. But we have to have a sense of fairness to the process. And timing is very important here. We're not saying, I remember when I first started practicing 30 years ago, there was an election that took 3 months to happen. And frankly, everybody, including the employer and the union, the employers got tired of it. We wanted the process to be over. And but that was another time, another board, another economy. We're talking here less than a month. You know, I don't understand the reason for the rush to do this. In our society, it takes a period of time to get a driver's license, to get a marriage license, to basically to change your Verizon account. It takes time to do these things. We're asking for, in a first circumstance, a period of time, 42 days, in order to have an election. Very fair. I think it works well. We don't have to go through the statistics. This is one of those situations where everything has been said, but it hasn't been said by everybody, where the numbers are known. But there, the 25-day period, that gives time, once the rules are set, for both sides, doesn't benefit either side, for both sides to now determine, express information to employees and determine whether or not they
But
should express it.
where in the current regs is that contemplated? The current regs, when they talk about this 25 days, does it say so it gives the parties enough time to play the fourth quarter, to have the opportunity to campaign with full knowledge of how the game is to be played? That none of that is in the regs.
But
the regs talk about a process that is set forth for particular reasons that we submit are non-functional any longer. There's no need for that. There is some value to the parties not having to have protracted litigation. Don't you agree?
I don't think it's a matter of litigation. I think it's a matter of information. See, you and I may be looking at this differently. You may be looking at this as a litigation matter. I'm looking at it a fairness matter for dissemination of information and for free speech rights. I come from a position, and I represent my clients from a position, that more knowledge is better than less knowledge. Knowledge is fuel. Now, information is important. Information may not always be in my advantage. But yet, let's lay out the cards. Let's lay out all the information. We're going through a presidential election process now. There's debate after debate. You could decide to listen to which side you want, but at least the information's there. Whether you want to listen to MSNBC or Fox or CNN, that's up to you, but the information is there. And to restrict that information is not the way we built our democracy, the way we've operated under the board. And I know you've had the experience, probably as long as I have, maybe longer, of 30 years of dealing with these rules. When you mention the issues there are certain mores of how the process works. If there are things to be changed and you have to tweak litigation, then let's tweak the litigation issues. Let's tweak the issues about litigation, of how to litigate cases and unfair labor practices. But that's when, if an employer violates the law, then let the employer go through the process of dealing with unfair labor practices, but not on the basis of an election. An election an employer has not been, an election employees have not chosen. You can't take away the free right of an employee to understand from both sides. And that's what I believe your proposal does.
Think further? And thank you very much
much.
for
Appreciate
taking
the
the time to
opportunity.
talk with us, answer questions.